talk us about how drafting and researching play such a pivotal role in dispute resolution.
Like that, or straight away you need to send an arbitration notice. What the arbitration notice says, what the arbitration clause says, everything is has to be looked into very carefully by you. You write has a very specific meaning, invaluable. When you prepare a draft, you're starting with the point, you start typing down, more thoughts come in, and at some point there becomes a situation where what you're saying below is actually inconsistent with what you're saying above.
In the legal profession of concise writing, that sometimes we write the same words which have same meaning five, 6 times over because it's the format that we have followed, but it is not needed. Actually, associates and senior associates like you do read that cover to cover, all these 10,000 pages, 5,000 pages.
Yes, I
Hello and welcome to the 10th episode of the ArbCast podcast. It is a matter of great privilege that we have completed 10 episodes today. And for this episode, I'm joined with Mr. Harman Sandhu. He is a senior associate at Singhania Partners LLP, focusing on dispute resolution in infrastructure projects, contractual disputes, and insolvency. Today's episode is something that is very unique and peculiar, which is that if you go online and see a lot of lectures and webinars done by partners and senior advocates, they speak from a very ivory tower in the sense that they do not relate to the associates and senior associates who work at law firms and chambers as to the what kind of work they do in terms of drafting and research. And most of our audience here are students and freshers in the profession. So this episode will actually help you understand and get a grasp of things as to what is it expected from an associate. Because only if you're a good associate will you be promoted to higher levels and become a partner eventually and attain greater roles in the profession. So today, since Harman sir has been in the profession, especially as a solicitor in massive firms such as Singhania Partners, he will talk us about how drafting and researching play such a pivotal role in dispute resolution. And also, today's episode validates a lot of what that we are doing because may I mention that today is the final day of the Delhi arbitration weekend. And instead of being at Delhi High Court and five-star hotels, Harman sir decided to take time and be here, speak to me. So that just goes to say I'm doing something right. So thank you so much, Harman sir, for being here, and I look forward to a conversation.
thank you so much for having me, and congratulations on your 10th episode. That's really nice.
Associates and senior associates do actually have a lot of work which can be considered as to be the backbone of the entire matter. So from your perspective, how does behind the scenes work of associates and senior associate actually drive the arbitration forward?
So, for an associate or a senior associate, I think I'll just go chronologically. So, first of all, when the client comes in, you sit in on a meeting, get a flavor of what the matter actually is, what the claims are, and usually get an idea ki, okay, this is what is going to happen. And depending on the conversation, you also get an idea how tough it is going to be, because like, it is obviously biased from their end, but then you get some sort of an idea of what's going to happen. So that's the first step. You sit in with the clients, you jot down notes, have your list of dates as per what they say, which is very informal, of course. Like, it's not gonna like influence your draft to a large extent, but just to get an idea. Then once the meeting's over, then you need to have follow-ups with the clients. You get the documents, you go through the documents, and a lot of times, what the client feels is relevant or an important document may not be, or it may be you need more documents, more substantiation, more evidence. So that constant follow-up has to go through. Now also, this has to be looked into with the aspect that it is not one client you're catering to at any point of time. This is going around for like 3 4 matters are going on constantly. So just being aware ki, okay, this not messing up ki maine kisse kya, or some very basic stuff, but it is something that you learn when you just join, you start practicing actually. Then you go through the documents for the follow-ups, and then you basically present a story. You build a story in your mind so that you can have a conversation, a detailed conversation, which is meaningful with your seniors, because obviously you're not directly going to start drafting or anything. You build a story in your mind, make jot down the main points, have a conversation with your partners, and depending on that, then probably you would have another call with your clients and all. And because it's an arbitration, you need to figure out whether you need to file a section 9 for interim measures, something like that, or straight away you need to send an arbitration notice. What the arbitration notice says, what the arbitration clause says, everything is has to be looked into very carefully by you. Now, then you need to go through the contracts so that there's a holistic understanding of what's happening. And then ultimately you go for a section 11 if that situation arises, and thereafter the arbitration starts. And yeah, this is the basic pre-arbitral steps, I would say, that you need to go through. And
Yeah.
yeah, that's how
So
it.
I think you talked about that the client comes to the office and then he tells you what the issue is all about.
Yeah.
So usually are clients themselves as clients, or do they come through as a referral, as a lawyer or a law firm? And many times a lot of these clients are not coming at the outset of the arbitration, but between, where they feel that they need your assistance and
Yeah.
legal advice. So what are the percentage? Like how many of these clients are actually clients themselves or other law firms and lawyers? And at what stage are they actually approaching you?
So for us, I think a lot of clients are people who we've worked with. So Singhania is doing 25 years this year. So we have a reputation and everything. So we have prior clients who come in. Like the matters are new, but the clients are same. So it's usually a new matter. So we don't have that much difficulty. But as you said, of course, there are going to be people coming in whose lawyers are not competent or for whatever reason. I should not be saying that, but for whatever reason they come in between. Or yeah, so then you have this conversation of what they actually want,
Hmm.
because it might not be that the lawyer is not giving them what they want as much as what they want is not something that is feasible. Then you actually need to sit down and at the outset talk to them about whether what they're asking is even right or not, because you don't want another situation arising which is harassing to a large extent to the client, that first they go to one person, another person, and it carries on.
Yeah.
So that is, it happens. Yeah, I wouldn't be able to say in as much as percentage, but yeah, a lot of the clients we get are fresh matters. Like clients are old, but we get fresh matters. Also, I think a factor here is that I'm working with a senior partner who's got like 30 plus years of experience. So he has a reputation of his own. So a lot of people just want to approach him directly and instead of going to any other place. So
Yeah,
yeah.
certainly, certainly. Um, so my next segment is actually drafting and arbitration, and a lot of my audience wanted this episode to come out, which is purely on how do we draft arbitration drafts, such as a notice of arbitration, a statement of claim, statement of defense. But we will have a detailed episode on that as to how can we draft all of these individually in the next few episodes. But if you could just talk about what is the chronology, or like how does it start? Obviously, it starts from notice of arbitration. What does a notice of
Yeah.
arbitration entail? What does a statement of claim entail? Statement of defense, etc. Do we actually have to rebut each para as we do in litigation in a statement of defense, as compared to an arbitration? And after a statement of defense, what actually are the drafts that follows? Because in arbitration act, these things are not mentioned because it is left up to the party as to how they decide on what they want to produce in
Yeah.
a court, in the tribunal or no. So just talk about the chronology of drafts that you experienced in an arbitration, and why do they exist, for what purpose?
So you're correct. It's not mentioned, but you would also appreciate the fact, which was also uh, taken up during the DAW, that a lot of arbitration in India is done by retired judges. So they already have a mindset that this is what the whole document list is going to be. So initially, yeah, the arbitration notice. I'll go very briefly. So basically, you point out the facts, like what your client is stating, and then you reproduce the clause, and you go. And also, you need to understand that before the arbitration notice goes out, you need to read the clause, the arbitral clause, or the dispute resolution clause, and do the pre-arbitral steps, because the language therein very important. If it says that something like a mediation or something has to be, shall be, or something like that done prior to an arbitration, those steps need to be taken earlier. You send an appropriate mediation notice or something like that. Then you draft a notice, you point out whether those steps were taken and how, you point out the relevant details, list out your claims, not in as much detail as you would in a SOC, obviously, but just of the, okay, these disputes have arisen and this. point out the contract clauses, something like a 2 3 page but sufficient detail. And then of course you go for section 11 if that situation arises, because usually it does. And also recently, because of independence and impartiality of arbitrators is come up as a big thing, so you need to go through your Perkins and core and realize what the arbitral clause is. Accordingly, it might situation might arise wherein the arbitration clause you need to state that this clause, though not applicable, we would like to go for arbitration. Accordingly, take the steps. Then is section 11 is something that courts have now regularly held. They won't really go into the details. They just need to see whether the clause is valid and legally tenable and just refer. So that is not that big an issue. So yeah, section 11, then the arbitrator is appointed. Next step is usually you approach the arbitrator as per the directions given in a notice in the order, section 11 order and all. You ask, then the arbitrator would probably give his declaration and everything, and then the first hearing, usually a case procedural order is passed, how the parties would pay the like the fees and everything. Those situations, if it's an institutional arbitration, those everything matters. Like that is all based on the case. I won't be able to discuss
Yeah,
that in much detail.
yeah, yeah, definitely.
Then, of course, if you are a claimant, you file your SOC. And if you want to interim measures, if you want interim measures, section 17 goes with that. And then SOD is filed. And like you asked, like it is a good practice that every paragraph is rebutted. You deny or accept or whatever. That's just good, because not categorical denying is something that is not a good practice, I would say. Like at least I try to, in my drafts, try to rebut every paragraph. And after SOD, then there's usually a rejoinder, which is, yeah. And then I think there's, so you need to understand during all this time there are arbitral hearings happening, which are procedural in nature, but then the timelines and everything, keeping that in mind, all these take place. Then usually there's a, you give your affidavit of admission and denial of the documents, either side gives of the other side. And thereafter you give the evidence by way of affidavit of the witnesses, which may or may not include an expert witness. So yeah, these are the main steps. Then usually pleadings are complete and everything, and yeah, the arbitral process continues.
Yeah. Also, speaking of pleadings, like once a statement of claim has been filed, as claimants, can we make additional pleadings in a tribunal? And how easy it is to amend a statement of claim? Because in court, it is not that easy to amend a plaint. Although you can, but it's not that easy. In arbitration, how easy it is to amend a plaint? A statement of claim. And can we have additional pleadings done in a tribunal?
It, I think it all depends on the stage of the arbitral process. So it cannot be a situation, or it rather should not be a situation where there's been a claim and a SOD and a rejoinder, and then thereafter you want some additional documents to be taken on record, which is, I don't think, a correct practice. Though there are case laws that they are allowed to raise, but I think in an arbitral process, because it's party autonomy, and if the other party agrees, and if it's a major issue of contention, then that is something that the arbitrator has to look into. Yeah, it's not as tough as in court, obviously, because this is an ADR process, not exactly litigation. So yeah, but it is like generally it is the best practice, like whatever you want to say, you say in the SOC, or at the most rejoinder. So there's this practice of whether if new issues are taken up in the rejoinder, then a sir rejoinder comes up. So
So
that
that
is like
follows.
case.
That may follow
Yeah,
throughout the
yeah,
arbitration. Okay,
yeah, yeah.
okay. And okay, so moving on, but staying on the same segment of drafting and arbitration, which is that most freshers and law students are very afraid of drafting because they have no clue as to how it is to be done in law school. Although we do have a course on drafting and pleadings, it is not that after completion of that course you probably can draft. It takes a lot of time and experience. So it is considered to be a very difficult aspect of practice. So my question to you is, which is a personal one, Just that, how did you learn how to draft specifically in arbitration matters? How long did it take you to grasp? And what were the common mistakes that you did, which also a lot of juniors that you see now are doing because you have a lot of interns under your supervision? So, what are these things that you notice that young freshers and students are doing?
So when I started my practice, initially it was like I started drafting after I guess 2 3 months of joining, and before that it was mainly going through the documents, understanding, because you need to realize that law is a very broad thing, and you can't straight out like join the profession, be like, okay, I'll do this and do great if you can, but it's usually not because you don't have experience. It's nothing personal, but you don't have experience to do that. So when I started drafting, it was more of drafting of applications instead of like main petition or SOC or a SOD in that. So you get a understanding of how you are actually supposed to write, and what are the main points you need to keep in mind. So I started with application. I think maybe a year and a half is when I actually started drafting the main petitions. And I think the first draft I did was a Section 34, like the first main draft. So that was pretty interesting. And yeah, so I would say there's an like in anything, there is an incremental curve to everything. It will look daunting to you, but once you get into it, then it's like, okay, this can be done. This can be done. I can do it this way, this way. So it's just you need to make yourself uncomfortable, start doing it, and you'll get to it. It's not that big a deal.
Yeah,
Yeah.
definitely.
What errors the
Yes.
newbie, yeah, associates do and all. So I think the first error people do is with respect to language, the accuracy of language. So whatever you write has a very specific meaning. Like interestingly, I don't know how this came up, but this has been etched in my memory. So when you write a word and you google it, there are synonyms and antonyms to it. But synonyms, you see, every word has a very specific meaning. They are synonym. They do not actually mean what you want to say. So you need to be very careful what you are writing. You can't just go find a better word and write that,
May I just give an
because your
example? May I just give an example?
sure.
Like an example for that can be belief and faith. So belief and faith
Mhm.
are used interchangeably, but actually the meaning is quite different. Faith is that you don't have evidence, but you still hold it to be true. Belief is that you have the evidence and that's why you believe it to be true. So that is one example where it is used interchangeably, but the meaning is not the same.
Yeah. I think you're speaking of this in respect of an affidavit when the
Yes.
verification is given at the end of.
Yes.
Interestingly, we have this matter going on in nahi, Faridabad District Court. And this issue came up very interestingly because the other side, it was a enforcement petition, and so affidavits are not really, that's a question that I should not go into anyway. So, but this question did come up, and he did cite a judgment of, I think, Punjab Haryana High Court, which say that it is illogical to say that you use both the words in the same sentence. So
Yeah.
it's quite, yeah, that that is, yeah, one example of it.
Yeah.
uh, Continuing with it, I think the second thing would be inconsistency. So you have to understand, when you are starting out, at least in my case, there are like 100 thoughts going on. Ki, this can be done, this can be done, this should be said, this should not be said, and they may be valid, they may be invalid. But when you prepare a draft, you're starting with the point, you start typing down, more thoughts come in, and at some point there becomes a situation where what you're saying below is actually inconsistent with what you're saying above. It may look logical when you're typing it down and thinking, "Ki, okay, this is a point I should take," but you need to also realize that that point may be countering some other point you've taken up above. And this is a situation that comes up, which I think would you would understand only with experience.
I think the best
Or
way to deal with that is like sometimes you want to mention two inconsistent parts, and that is why you can perhaps write in the alternative. So in the
in the
alternative, we
alternative,
can say
without
this. Yeah.
prejudice to the
Yeah.
above, yeah.
Yeah.
But still saying that is one thing, but still you need to be very clear that when you are actually arguing court, how do you want to proceed with these two inconsistent points?
Hmm.
you know so one is that. Then I think, Sentence formation is something we need to work on because English is an issue, and people do face that. And sentence formation has to, like, a lot of drafts I've seen, like, they want to say something, but the words used or the sentence formation makes it kind of illogical. So that is something that is very personal and person to person, but that is an issue I've seen. Then also, I think the most fascinating thing to me during drafting in my early years was like when I used to sit with my seniors and they would be typing something down. It's very interesting to see how they use the language they use, gives makes the sentence not so restrictive that you cannot, have a leeway of arguing something else, but it is also not that broad that what you're saying makes no sense. That balance of writing things in a manner that in the court, if something you've, like, a situation might arise with this thing, this point might come to bite you later on, but you give that much of leeway that you can somehow play it some other way. So that art is something you need to learn, which will come through experience, reading judgments.
Yeah, and nowadays there's this movement in the legal profession of concise writing, that sometimes we write the same words which has same meaning uh,
Mhm.
five, 6 times over because it's the format
Yeah.
that we have followed, but it is not needed. Like you mentioned, like sometimes documents are voluminous, especially in arbitration. Arbitration is notorious for like 10,000, like 5,000 pages of documents and case files to be read. So my question is like, I actually have worked on arbitration, but not like the complete arbitration from start to finish. So I'm very curious like personally also. Like, do actually associates or senior associates like you do read that cover to cover all these 10,000 pages, 5,000 pages? If you could just talk about that, like, do you actually do that?
Yes, I would say so. You need to understand that it's not done. All of it is done like at one point in time. So you meet the client, you get the gist of what's going to happen. You call in for the documents. The first document you would be getting is probably the contract, which itself is like 200, 300 pages. But that is the most substantial document there's going to be. So you go through that, you flag everything, you mark out, ki, okay, these are the important clauses and all, and then you send out your whatever notice or application you want to file. You do that. So that is one part done. Then you get the doc, and also it's like you don't need to do it, there's any timeline that you need to do it in 3 days, 4 days. You take your time, but be thorough with it. That is how I've been doing it. Like, and I think to an extent, my seniors have been gracious enough that they allow me the time. Like, if I say, "Ki, I need 7 days," they also have this belief, ki, let him do it in 7 days, but at least then we'll have a whole, everything will be known and there's nothing left as such. No point in creating, unnecessary emergency in stuff like this, is what I would say.
Yeah, this is
So,
not
yeah,
comforting to hear.
I think this also, so I think we'll probably talk about it at the latter end of this talk. But I think it's also firm to firm based, like what team you have, how much that those are factors that do play out. And going back to that, yeah, and also when you go through the documents, I think the first time you go through it, you get an idea. Ki, okay, supposing March 23 to June 23, this is what happened broadly, because it's contemporaneous correspondence. You don't need to rectify or mug up every document. You just need to have a general idea what's happening. Okay, June this happened, then this happened. So you have a broad idea of this is going to happen. So when at the time of drafting, when you are like, okay, I've written this. What was its impact? Something changed in the month of November. So you go look at the correspondence of November and you find a document. So it's easier that way.
Yeah.
Also, when you're drafting, you're going through the same set of documents like 10
Again.
times, 15 times. It's not like you'll be reading it once and it's done. Because even when you are filing, you're filing the documents, you'll only file them after reading through that. So it's not that big a deal. I think it would be more cumbersome for people who are appearing for NHAI or those type of contracts, which it's like volumes and volume. I haven't done a proper, like, I would say 10,000 or 20,000 page volume. I've done arbitrations up to 5, 6,000, but that's been fine. It's okay. You
Yeah.
just need time for it, and also you have a team, so it's not like everything is on you. I do personally like going through everything once myself before relying on somebody. But yeah, you have a team, so that's fine.
Yeah, certainly. But my next question is actually a follow-up to this question, which is that you read so much, right? And obviously it's happening over a period of time. And like you mentioned in the outset, that this is you don't really have one matters. There are like ongoing 4 5 matters at the same time, and sometimes even
Right.
more depending on office and teams. So, how do you? What are the tips that you may like to give to our freshers and law students on how can we retain so much of information? Because there's so much of information that you may even if you read, but how can you actually retain that? So what practices do you have to ensure
I
that you retain such information?
I am, which may be not entirely correct also, but I personally do not feel that you need to retain everything. So I am very diligent personally in making notes. So when you haven't, like, obviously you've gone through the material, you know the broad things. So nitty gritties can be something you've noted down. And I think this may be related to your AI. It's not exactly AI, but somewhere technology, like you have liquid text that has been a game changer in a big way. So you can just have a note and your whole thing on the left, have your notes here, so it's done. You need to spend, like, if the matter is coming tomorrow, you need to spend like a couple of hours going through it, revise your case laws, find out any new case laws, so stuff like that. So you have your note ready, so you don't need to mug up. Nobody is expecting you to mug up. There are broad facts that you need to remember, which I think anyway, if you're reading through the same thing 10 15 times, it's gonna get retained. It's not something that you'll forget. So that's, I think, retention is not that big an issue. Also, then if you have like 5 matters, who's doing what, and not also matters are not like every matter is at the stage of final hearing or
Mm,
something. It's not that key. There's constant pressure of key, okay, I have to prepare for this, I need to prepare this much, this I need to prepare this much. This is not, like how you have those management techniques of writing down urgent and important, important not urgent, urgent not important, stuff like that. So you categorize your work in that and give adequate time to each. Also, you get dates, you know when the matter is going to come up. So there's no point leaving it to the last end and then thinking ki, okay, there's so much pressure. You have your, and usually in arbitration it's like 2 3 months date you do get in the initial filing of SOC SOD. So that period you get 1 month at least, you get. Then for court cases, 2 3 months is a normal practice nowadays. So you know when the matter is going to come up. You have weekends. I Now this question does come up, how much work life balance is, which may be a controversial topic right now. But yeah, when what is going to happen. There can be exigencies, you just plan for it. Good planning is, I think, the
yeah,
way
I think
forward. Plan.
weekends need to be vacant. Otherwise, how will Harman sir have this podcast?
This is true.
You know?
This is again planning. We had this talk like 2 3 weeks back, so I
Yeah.
planned out, okay, this, yeah.
Yeah. No, but
So
it is important. I think every even like an associate level needs to have a calendar and ensure that that calendar is followed because again there are people who may have but not never followed like me. So yeah. So moving on to the next question, which is that you started as an associate. I think you started working at Singhania, like your career
yeah,
started
yeah.
there, right? So you
Yes.
have now moved from an associate to a senior associate, and there are a lot of people who actually do get such opportunities in such big firms as an associate, but somewhere midway they lose motivation, they leave, and if not leave, it takes time for them to get promoted, etc., etc. So, what has helped you what habits have you helped that allow you to grow from a junior associate, like an associate to a senior associate? That is one, and this is also a follow up to this one also that it is often said that an associate or even a senior associate may not know the law so much, may not have so much of experience, but what is expected of them is being professional. What does being professional even mean according to you now that you have stayed in the profession for enough time? And by professional, I don't mean like being on time. I think that everybody knows. But what is it that the partners in especially dispute resolution teams specifically like to see from associates and senior associates? Because certainly they can't expect them to be senior advocates, right? So if you just
Yeah,
talk
yeah,
about.
that. Okay, so I will start with. I think I'll answer this in one flow, saying that what I'll talk about what I think is professionalism, and following those is probably what got me to a senior associate position, I would say. So professionalism is basically, you have skill and experience. You cannot do anything about experience, right? So only thing you can do is with respect to skill. And law is a profession where skill can only be gotten by reading, more reading, and then some more reading. So I'll give an example. Like every application, be it a section 9, be it a section 17, up till filing an SOC or even a section 34, 37 SLP, I have a conversation like whenever that uh, uh, particular task is given to me, I have a conversation with my seniors. Ki, okay, you've given me this task. I need to, like, if it's given on Friday, I'll have a draft ready on Monday, Tuesday, or what. But I personally am very clear. Ki, okay, this is the timeline I have. I need to go through it. Now, what happens in that is I'll go through commentaries on that particular subject so that I actually know the law of what I'm going to be writing and what facts I need, everything. So you go through the commentaries, you get to know the law. That is how you build your skill. uh, I'm not saying everything I write is 100% right, which is obviously not. But then you have that much confidence that I know this. I can have a conversation with my seniors, given meaningful inputs, and actually substantiate that why I'm writing so. Rejecting it or keeping it in the draft is something separate. That will be seen later on. But putting in the drafting, having a logical answer to everything is something that you need. So that is something I think was there in me, that I need to read, 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 read case laws. Then, second thing that comes in is a lot of times. So law is nothing but logic at the very end of it. So whatever you're thinking, you think logically, that would probably be the law, in the sense that somewhere something like that would be said. So that is the end. But when you're writing your logic into a draft, it cannot be unsubstantiated. So you need to do your look for case laws on that, read your maxims, something like something you need to be, at the end of it, you need to substantiate it. So that you, when you prepare your draft, whatever you, again, it's the same thing. Be it commentaries or be it case laws, whatever you're writing, have substantiation for it. And I think that also reduces the work for your seniors, as in they can trust your draft. They know, okay, this is the case law, he cited it from here. They can go through the case law and be like, okay, this can be put in. That just reduces it. Like most of the effort you do put in yourself is reduced effort for your seniors, which is, I think, anybody would want to see like the junior do. So that is one thing. On a more practical aspect, I think it is, you need to observe. So a lot of initial months in my career, it was like my senior partner would be drafting, like he would be dictating, okay, this is, you need to observe what kind of language is used, how it is spoken, why is it spoken, observing that again will come through experience. It's not something you can force ki aaj main baitha kal I'm a, I'll know everything. No, but just way, little by little, just understanding why, what's done in what manner, you need to understand that. In courts, you need to observe what is argued, why it's argued, how it's argued. So that is something. I think I do have a couple of other points. I just jotted these down. You, one sec. Yeah. So also, this is a very solution based profession. Professionalism with each profession is professionalism for each profession is something separate. We are expected to give out solutions. Problems are there, you need to just find out solutions. So out of box thinking is of course there. Some innovative thinking has to be there. Rightly, wrongly is something that will be seen later. But put in your effort, give a little bit of time to that matter, think over it, analyze it, whatever comes to your mind, have a conversation, frank conversation with your senior. It may turn out to be right thing, something like that. Then secondly, I think the which also I would say comes through being in an organization or your setup for a while, but you need, ultimately start anticipating of what is required of you. So if you're given some task, you have to know what the logical next step is. Prepare for it beforehand. It cannot be that everything needs to be told to you. As much as you need to be prepared, okay, this is the logic. I'm not saying that you do everything, like have everything ready and then go, but step by step, at least know what the next step is going to be, prepare for it, and jitna bhi, how much ever ready you are, time constraints are always going to be there. Just, I think that much is, yeah.
Yeah.
And I think I would need to state it here that in my particular case, I would, like, I've heard stories of all kinds of, teams and everything. My team in particular has been I think, touchwood, a very great atmosphere. My seniors have been very encouraging, right up from the senior partner to mid level to, like, to me, everybody is available for having conversations, meaningful conversations, talking about law. It's not like you are snubbed or anything. You may be wrong, which is absolutely fine. You have to be wrong to learn. But there's no, at no point it has been a situation where, despite the time constraints, we said you don't, like, keep quiet. It's not, it's never been that way. So yeah.
I think that was a very good answer, honestly. And if I just may talk on professionalism, so earlier this year, I was taught by Mr. Siddharth Raja. He's a corporate and transactional lawyer on M&A. It was an elective course in my college, and he's a senior partner at Vertices Partners. And he basically said that professionalism is nothing but doing what you're supposed to do without being told to do it. I think this is also you
Yeah.
mentioned. That I think was the
Yeah.
second last point. So that is like articulating a articulating it to a very good extent. And I'm likely to have Mr. Raja on very soon on the podcast. So
Okay.
that is we'll talk about
That'd
this
be
in
nice.
depth also with him. But I think this was a very insightful answer. And one last thing that I would like to ask you is that now that you have become a senior associate and you have seen law, and especially like from a young age, and you have witnessed your own growth. What are some things that you would like to just, the floor is completely yours now because we're concluding. Just what I like to say things to young people who you were in their position like a few years ago. Like what would you say to your own self now that you're here? That do not be that anxious. Things will fall into place. Just do this, do that. Like those type of things. Like motivate people who are watching this. So especially in the dispute resolution in sector as a sector.
So I think dispute resolution, of course, is a, it's something that you need experience. You need to learn. It will take time. There's no way around it. That will take time. I would just say you put in the work, be it whatever. So being an associate, uh, filing, going down to the file room, getting a file, knowing how files are kept, every there is, this is one profession you cannot have an ego. If you have an ego, you will fall back. So I, like, everything I've done filing, I've done what, gone to the registry with clerks, which is not to say something exceptional. It is something I think every associate should do. They should know the basic processes, even if of their own firm, that how work is done, what goes on behind, not just limit yourself to drafting and be like, get me the file and do that. Know everything about how anything functions. You don't know when it's going to be required. So that is something, I think, just be, have integrity is what I meant. Read, what you, I think everybody who goes into this profession knows what's required. It's just, pushing yourself over key, okay, whether I do this or make an excuse. It boils down to that, which is, I think, true for any human work that you, be it sports or anything. It's just those same things that boil down, so it is that. I would say respect your seniors, because this is a profession where you cannot be actually stepping on toes, and understand why, whatever is being sent, why is it being said, sorry. And because a lot of times, we being advocates, we don't say it out directly as much, but there is an intention of making a junior understand what is to be done, but you say it in a very subtle way. So having that nuance, which I think actually does play out in codecraft also, having that presence of mind, okay, this was said, there was an intention behind this, what it was. So that is there. uh, it's not going to be easy, which is absolutely fine. It is not supposed to be easy. There are so many lawyers churning out every year, we know that, which is kind of a problem, and it's only a few who have actual substantial jobs doing meaningful work. So if you want to get into that, there cannot be an excuse. Um so I think, yeah, that is it. I think it's just having uh, like I the reason I did say all this is because I have been seeing this in a lot of interns or even associates coming in, which may be generational or otherwise. I don't know why this is like, I never felt it that way. Maybe it be personal, but they think that this is what I'm supposed to do, so I'll do this you cannot ask me to do, or I'm not willing to do, or you tell me to do, only then I do. This is not something that should be there. You should have that inquisitiveness, and that, I think, just that thing, I need to learn whatever it be. Let me learn. Do it once. Nobody is asking you if there's something you are uncomfortable with or doing. Uncomfortable in the sense that personally, not professionally. In the sense, if you are uncomfortable drafting, doesn't mean you stop drafting. You draft again, you draft third time, you do it 100 times till you're good. But like, learn everything about your profession, be it uncomfortable or otherwise. You not need to repeat everything, but yeah, experience it. That is the only thing I would say.
And on a lighter note, you mentioned started this answer by saying that one should not have an ego. But ironically, people say that every lawyer has an ego. So that's one thing. That's like a lighter
That
note. I
is
don't mean it. Yeah.
I think that is true. Like ego, you should not have qua yourself and your work. There will always be ego when you step into the courts.
Yeah.
Ki maine ye padha hai, I know this. I'm going to say this. I have to win. That should be there also to an
I
extent,
can't lose and all
which should
that
not.
stuff. Yeah.
Yeah, yeah, which should not be overpowering also. But somewhere that will be there. I'm saying ego should not be ki this work is beneath me or
Oh
something.
yes, yes.
That cannot be a position in your life ever,
Hmm.
you know so
Yeah.
whatever is required at that point, do
But
it.
if I may challenge you on that, sometimes, like,
Mhm.
especially, I will not name the firms that I've interned with, but there were firms I really was looking forward to intern with because of the type of work they do and etc. And once I got the internship opportunity, the type of work I got was very underwhelming, like filing, not even filing, like just arranging documents based on the dates and stuff like that, which is fine if I have to do it one day for 2 days, but the 3 weeks and 4 weeks, I don't think that's fair because I'm a law student, I've come here to learn law and obviously they're not entitled to teach you also because it's a firm, they have to cater the clients, they're not there to cater you, but like still there is an element that if I want to grow and for that I have to do meaningful work and arranging documents as per dates is not something that will help me grow. So what do you have to say on that if I may challenge you on it?
uh, See, being an intern, we also need to realize that we are there to help the team we are with. We can't at all points be like imposing that, give me this, give me that. So that at some level is something that you need to deal with. And it's like, if you want to learn, there's no uh, there are multiple ways to learn. You uh, talk to a team. They may be like, what matters they are doing, right? They might be asking you to file, but you know what matters they are doing. So take out your time, read up on that, maybe put in inputs. If they don't want inputs, which is like, sometimes there can be a situation where it's very limited time they have to file something, like 2 days you need to do this, file it. So they cannot be waiting for your inputs, which is fair enough. But you can, at the end of it, everybody wants to just grow. Which is, so how would you grow? You've read up on that, you've read the case laws, maybe write an article about it. Who's stopping you? That is not something that the firm is going to say, don't write. Maybe you find a good senior out of them. After the filing is done, after that chaos period is over, you'd ask them, okay, went through this matter, this is what I found was interesting, I wrote an article, maybe you help me, reframe it, or help me publish it, something like that. There is not one way to success, is how they say.
Hmm.
Whatever, again, it boils down to that, whatever chances you get, whatever, nobody's obliged to give you chances.
Hmm.
Jitna bhi, whatever position you are in, whatever chances you're getting, limited chances you're getting, take them.
Hmm.
Anything extra you need to do for yourself, and that is what's satisfying, I think, at
Yeah,
the end of it.
I 100% agree with you on that. So I think the
I
main
would just
yes, please.
Sorry, I would just say that I do know of an intern who used to, intern at our offices, and by reputation, I also know some other offices. So the team that person was in, if there was no work by the, so basically it was for like a month or a 2 month internship. By the end of it, every team in the respective offices knew who she was because she had taken work from everybody. So it's not like, if you have the will, then maybe find a way. If you can't, then do it. Like I said, that if it is a situation you can't go to another team, do your own thing. Why not?
Certainly. And like I've also done like eight, nine internships and I'm down to do more. And I've seen like the interns like who actually eventually became associates in those firms were the ones who were the first one to come, last one to leave. And they were not at all shy in asking for work and being around and being known. It doesn't like even if they knew that they are being a pain to certain people, they still continue to be there, just make sure that they are seen and let no matter what comments they had to make, eventually you have to make a name for yourself, and if you have to do it through this means, then do it. So certainly I definitely agree with you on that point. And I think today's episode, I think, is very insightful. I think you a lot of what we have discussed previously in past episodes more or less have been covered by arbitration conferences or other podcasts, but I think
This
this
was, I think, more of a humanity kind of side of it.
yeah, like
What
this
is the
episode, I think
person
you
giving
this
out?
something like this, like especially drafting in arbitration, you will may not find otherwise. So you are doing something new, and wherever there is new, you probably will get results. So I'm very grateful to all my audience that have been watching me for the last 10 episodes, and there are 10,000 more to come with amazing guests. And we look forward to hosting Harman sir again, and become when he becomes a partner, and we'll talk about how to be a good partner.
Oh, I'm so lucky.
Okay, thank you so
Thank you
much,
for
and
having
enjoy
me.
your evening. Thank you.